Good evening. Let me go ahead and get my share screen up here and get the right screen going. There we go. All right. Good evening and welcome. This is our week 3 quick little live meeting for business law. We're going to go ahead and take a look at the topics that are being covered in week number 3. This is already, if you look at it, we're already at the midway point of the class, and we've had 2 weeks of interesting topics, and now we're moving on to this week, and then we've got 2 more to go after this. So our live meeting archives worked better last week, and the YouTube actually worked. So I think the changes that I had made seemed to work well. We'll cross our fingers again that that's the case this week. So let me go ahead and come on in here to week number 3, which is August 1 through August 7. And let's take a look and see what we have. You have your reading, which is chapters 3, 5, and 8 in the textbook. And as you can see, as usual, we have a video of the items that are in the week 3 tasks. And we're looking at some financial information here. If we go back and we grab the text that you could be looking at for the week, let's open that up and take a look. It takes just a little bit here to create the PDF. There we go. Okay. So the overview, what are the rights of the employee? What are the duties of the employee? What are rights of employers, duties of that are owed to the consumer, and rights of the consumer? Okay, so they talk about privacy here. Privacy is an interesting issue because I think a lot of people think that privacy is a right that you have from the Constitution. You know, we have rights of life, liberty, and the pursuit of happiness. However, nowhere in the Constitution does the word privacy occur. There is an inference, I guess I would say. It is implied through a lot of the other items that the Constitution covers that the Founding Fathers must have been worried about us having some sense of privacy because of things like the right to bear arms, the Fourth Amendment that says that we have a right to be free of searches and seizures, for the most part, unreasonable searches and seizures. So if you start looking through the different amendments, you see that a lot of this has to do with you and I being able to have freedom from the government controlling us. And so privacy is the thing that we think about first. So privacy is an interesting issue to take a look at. And there are a lot of things going on right now, and they talk about some of them right here. The government wants to thwart terrorism and crime. Employers want to find out if their employees are productive and loyal. Companies want to know their customers' preferences and their competitors' strategies. But how do you balance this with the right of people's privacy? So a lot of what you'll read about and hear about in the legal field, you'll hear people refer to balancing. It's a balancing between taking something from someone and giving it to someone else. So in this case, the balance of taking someone's privacy under certain circumstances versus what giving that privacy or taking that privacy gives to maybe the community overall. So take a look at privacy issues this week. Privacy in the Constitution, again, the Supreme Court has created 3 stands of privacy rights: privacy regarding family and sexual life, privacy rights that prevent the government from publicizing information that we consider intimate, and unwarranted and unreasonable government searches and seizures. Again, you see what it says. The Supreme Court has created it. Now, the job of the Supreme Court is to interpret laws. So the Constitution is the ultimate law of the land. The Constitution does not, as I said earlier, come right out and say that you have privacy rights. It took the Supreme Court interpreting the Constitution in court cases to create this sense of legal privacy that you and I have. So you can take a look at those items. They talk about surveillance at work, employer privacy rights and duties. What kind of information can an employer keep confidential about their company? And what about privacy rights of the data of consumers? You know, we're hearing more and more about companies being hacked, and when their computer systems get hacked, suddenly sensitive information like people's social security numbers and addresses and ages, birth dates, all of that stuff being hacked into. Companies or employers have the right to seek customer and competitor information and use surveillance techniques on their own employees. Individual or employee has a duty to protect confidential information of a company and the privacy rights of the data that consumers give them. And they also have a right from government. They have a right of privacy from government in aspects of personal lives, like they talked about above, sensitive information being seized by the government, and illegal searches and seizures. That falls underneath the Fourth Amendment. Okay, workplace safety. They talk about workplace safety and health in 2005, corporate criminal liability for the federal government and then your state government. So they break that down into two different areas for you to take a look at. Product liability duties to the consumer. If you are a company and you are creating a product that is going out to be sold into the public, what kind of duties do you have to the public that you are selling that product to? Government regulation of product safety, the Consumer Product Safety Commission, the FDA, the EPA, OSHA. When it comes to workplace safety, it's the Occupational Safety and Health Administration. That's OSHA. Product liability, they talk about the Ford Pinto case here. And if you take a look and do a little bit of research, you'll find that the Ford Pinto case is probably the grandfather of all product liability cases. Basically, the company knew when they were designing the Pinto that there was a design flaw that caused the gas tank, because of where the gas tank was located, caused it to explode if the car were hit from the rear and at a certain angle and at a certain speed. And they were, the funny thing is, back in the 70s, of course, they didn't have email. And so now everything is a lot more traceable. Somebody wrote a memo to one of the upper management saying, hey, I think we might have a problem here. And that memo got leaked out years later. And that was one of the key pieces of evidence to help prove that Ford knew that there was something potentially wrong with the car and decided not to deal with it. The bottom line is that companies know that everything that they produce, everything that they create and sell has some potential of being dangerous to people. I mean, I don't think anybody who makes silverware, butter knives, expects that people are going to go and kill people with them. However, it is it's a fact of life that you can take perfectly benign items in your house that were created for good purposes and do something bad with them. So companies create items knowing that there's a chance that they're going to be sued by somebody who's been hurt by their product. But companies take calculated risks. They have actuaries, people who like to crunch numbers, who will take a look at things like, okay, how many Ford Pintos are we going to put out in the marketplace? All right. Of them, how many of them are going to, how many cars on the road per 1,000 or per 10,000 get into an accident each year? And of those, how many are hit in the rear? How many are hit at this particular angle at the type of speed that would be needed to cause the gas tank to explode? And they figure out, they calculate all these numbers, and then they decide, okay, so how many people would potentially be sitting in the back seat or in the car when this took place? And they look and see, how many people, technically speaking, could die or be injured. And then they look and see, okay, well, how much would we have to pay out someone's family if this were to happen to them? And they look at that, they look at those numbers, they calculate the amount of money that they think that they would probably have to pay out in lawsuits over their product versus the amount of money that they're going to bring in by selling the product in the first place. And it is a calculation. And if there's enough difference between what they would have to pay out and what they would bring in, then there's a good chance that the product gets created. And the mentality is, well, we don't want anybody to get hurt. If they do, we'll pay them. And that is a calculated risk that businesses take. Businesses can't worry that every time, they, like I said, they create a butter knife, that butter knife is going to be used to hurt someone. If that were the case, and if everyone who had ever been hurt by a butter knife was able to sue and get a lot of money, then you and I would have forks and spoons and we wouldn't have any butter knives, because nobody in their right mind would produce them if they thought they were going to get sued every time someone got cut with a butter knife. They also give you the Tylenol case here. 1982, 7 people died while taking Tylenol. Someone had put some cyanide in a few bottles in the Chicago area. It wasn't caused by Tylenol. Tylenol, which was made by Johnson & Johnson, they recalled everything. They took it off the market. They took it off the market and created a lot of the things that you and I think of now as safety issues with over-the-counter medications, like the sealed containers and the plastic around the necks of the bottles and hard-coated caplets. So a lot of these things came about after the Tylenol scare, and business people thought that Johnson & Johnson was crazy to pull it all off the shelves. They said people are going to go use other brands of pain reliever and you're never going to get your market share back. Well, what happened was when they put it back on the market, they knew they had a safer product, and people felt so good about Johnson & Johnson because they felt that Johnson & Johnson cared about them as people and their safety more than Johnson & Johnson cared about putting money on their bottom line. So it's the reverse of what we look at when we look at the Ford Pinto case. The Ford Pinto case, it was, looks like Ford didn't care if some people died. They were going to make a lot more money than they had to pay out, so they took that calculated risk. Whereas Johnson & Johnson turned around and did just the opposite. They didn't take the risk. They took everything off the shelves. They lost a bunch of money, but they gained customer confidence. So as this shows here, here we are, 25, 35 years later with these cases, and we're still talking about them in business law classes. And they are good cases. All right, so let me get rid of this. Let's go back then now and take a look at your discussion. The discussion says, in the tort of negligence, what must the injured party or plaintiff establish to begin a lawsuit against a manufacturer? So negligence comes in a couple of different varieties. There's negligence that you and I cause as individuals, and then there is negligence that is caused by a company who is creating something. Sometimes you look at to see if we are looking at a faulty design, or are we just looking at a defect in this one specific product. So in the Ford Pinto case, That was a design defect. That was a defect that touched every single one of the Pintos that was produced. So it was a flaw, it was a defect in the design. Versus, is it just a faulty unit? Could be that you bought a car and the design was good, but there was a problem in the manufacturing. And there was some sort of a problem with a part so that the seat belt doesn't engage the way it should. It's nothing to do with the design of the car. It has something to do with that particular unit that came off of the assembly line with a problem. So take a look in your reading and do some research on what it would take for a product liability case. What a product liability, and how is strict liability different? You'll do some reading about strict liability. Basically, strict liability, you have no excuse. Let me give you an example. In a regular negligence case, if you were driving down the road and somebody threw a ball out in the road and a little child ran into the road and you swerve to miss the child, and you run over my fence and my roses, I can say, well, that's, it's negligence. You should have you should not have done that. And I want the roses and I want my fence fixed. And your defense could be necessity. I did it because I was doing it to not hit a child. Now, what would happen is you would be found to not be negligent, but in reality, your car insurance or your property insurance would probably end up paying for my fence and my roses anyways. And it wouldn't be worth it, or I wouldn't need to sue you. But if I were to sue you, you would have a defense. The defense is necessity. If you're driving down the road and you have a heart attack and you run into my fence and run over my roses, same type of thing. It was an emergency situation. You weren't driving down the road intending to run into my fence and plow my roses over, but you had a medical event that took place. That would be a defense to the charge that you were being negligent. Again, would insurance or somebody pay? Probably so. But as far as a court saying you were negligent, they would probably say, well, no, you had a defense that bars them from finding you negligent. In strict liability, there's no such thing as a defense. If you're found to be in control, you were in control or should have been in control of the instrumentality, the thing that causes the harm, then you are going to be liable. Okay, with negligence, we look at liability. Guilt is for crimes. Liability is for torts such as negligence. You're not guilty of negligence. You are liable for negligence unless it's criminal negligence. And criminal negligence is something different than what we're looking at here. Okay, so that is your discussion board. Make sure there's 250 words for a main post. Then you have your quiz due on Sunday, the live session, which you can do your overview of to earn the 10 points. That's what we're talking about here. And your homework due for Sunday. Again, take a look. This is 500 to 600 words. Read the case Denny versus Ford Motor Company and answer the 3 questions on page 293. Denny versus Ford is a famous case against the Ford Motor Company. So take a look at that, read through it, answer the 3 questions that are on page 293 of your text, and that will take care of your paper for the week. And you can see again 500 to 600 words. All right. So that takes care of it for this week. Now, I'm just going to let you guys know that the next 2 weeks, I am going to be technically on vacation. I will be still reading everything and grading everything, and I have plans to do a live meeting to record it for you guys, just like I normally would. However, I will tell you that I am going to Alaska. And the places that we are going, we have been to most of them before. And if things run the way they have in the past, we have been able to get pretty decent cell phone service and internet service. So my hope is that that is going to be the case when we're up there this time. Now, having said that, I've not tried to record live meetings and create YouTubes. So if for some reason I try to get on and record something next week and there's not enough bandwidth for me to do it, I will post something in the announcements in the news form letting you know what's going on and asking you to give me a synopsis of something else kind of in the place of the live meeting, and directing you to email me if you have any questions about the tasks. All right. So that is the plan. So I hope you have a great rest of week 3, and I look forward to talking to you from Alaska, knock on wood, next week for week number 4. Take care and make it a great one. Bye-bye.